Well, hello, everybody. This is another edition of Zoom Landlord-Tenant Talk Radio with your host, Attorney Dennis Bloock, coming at you every Saturday at 3 p.m. I'm glad that there's so many people already in the room, and I see a bunch of hands raised, so we're going to get to those in a very short moment. We talked, the song today was, what was the song today? Oh, I know. It was Donna Summers and Barbara Streisand, and the song was entitled Enough is Enough. And why did I say that or bring that song on, ladies and gentlemen? And the answer is because enough is enough with the city of Los Angeles. The city of Los Angeles has a little bit ago has commissioned the city staff to study the cost and feasibility of installing air conditioners in all rental units. This is a study that unanimously voted by the City Council of Los Angeles. And their reason for studying whether these should be put into every apartment unit is because there was a year ago a 10-day heat wave which broke temperature records across the state. And they went on to say that emergency crews saw an alarming increase in heat-related emergency calls as residents struggled with the extreme temperature. And they're afraid that this measure would be a life-saving measure for countless Angelenos during extreme heats. What we have here, ladies and gentlemen, is another money grab by the city of Los Angeles, putting this phony problem on the backs of landlords that they're not only going to have to purchase air conditioners, install air conditioners, they're also going to have to maintain air conditioners. And if your building is on one electric meter, guess what, ladies and gentlemen? You're going to be paying for the cost of those air conditioners, which you know the tenants are going to run 24/7. How is this fair? Why should this phony problem be placed on the backs of landlords? But that's what this city is all about. This city is attempting at all costs to hurt mom and pop landlords, put us all out of business. We're only going to have big corporations which are going to be running all income property owners, or the city will force landlords to sell their buildings so that they can put in homeless populations. This is where we're coming to, ladies and gentlemen. This is where our city council at work, all the 3.5 years that landlords could not enforce their property rights, could not go forward with an eviction, could not even file a civil lawsuit for all the rent that was not paid and legally not paid by the city of Los Angeles. So this is just another boondoggle which will cost landlords thousands and thousands and thousands of dollars where there is no need for it. I don't know about you. I don't know how many people have died from not having an air conditioning or had to go to the emergency room, but they take these anecdotal figures that emergency crews have determined. Please give me a break. So what we have once again is a situation where landlords are faced with paying for all these appliances, maintaining them, paying for the electricity, and paying for the installation. This is insane. I do want to call your attention now to something that's coming up as of February 1st. That's coming up just in a few days. I want to share my screen once again. And let's see, let's do that right here. So hopefully you're seeing what I'm seeing. And this is dealing with COVID rent for the city of Los Angeles and being finally able to enforce our property rights. Any rent that was owed in the city of Los Angeles from March 1st, 2020 through September 30th, 2021, we can immediately bring forth an eviction right now today, because that was effective, as you can see from the chart, as of August 1st, 2023. It did require a 15-day notice to pay the rent. It's got to be specially filled out where you're listing each month what was owed and what was paid for each month. So it's not a standard 3-day notice. It's a 15-day notice with special requirements. Now, as of February 1st, which is just coming up next week, any rent owed, COVID rent, from October 1st, 2021 through January 31st, 2023, that's now due on February 1st, 2024. There was a woman last week who said, when I told her that it's only a 3-day notice, that is true, but there is an exception. If you're serving rent that was owed from July 2022 through January 31st, 2023, that is a 30-day notice pursuant to the county rule. If you're serving a notice from October 1st, 2021 through June 30th, 2022, then that would only be a 3-day notice. If you're combining the periods all in one notice, then you're going to have to go with a 30-day notice. And by the way, that does exclude, as it states there, any months that the tenants provided certification for COVID hardship. So you don't got to take this information down, because I'm going to post this on YouTube. And so you can just freeze the screen. So don't get your pens out. You'll see it up probably before the evening is out. So right now what I'm going to do is I'm going to stop sharing. That was my sermon for today. We're going to now pick on people. Remember that this telecast, this Zoom meeting, is for informational purposes only. It does not substitute for getting quality legal help, even though I think I am quality legal help with 47 years in this wonderful area of law. Also, if you do want to talk, please, as I see so many people are doing, raise your hand. Please try to keep electronically, that is. There's a little button on the bottom. If you don't see it, then go into a box called reactions. It might be in there. Otherwise, you'll see it in your toolbar on the bottom. I'm going to try to pick on as many people as I possibly can. We've got a very big audience today, I'm happy to say. And so please try to make your questions succinct and to the point so we can really get to everybody. I'm going to start the show off with one of my old-time favorites, but she's not old. She's very young, though I've never seen her. And her name is Dina. Dina, I'm going to ask you to unmute yourself and take it away, young lady.
Hi, Dennis. How are you? And thank you so much again for doing this. I'm going to go very quickly for two things. One of them is following up for your valuable, what do you call it, the lease agreement on your website, when we can get it and so we can use it. That's number one.
You mean, where do you get it?
No, because I think you're revising it, you said, by the end of the month or something like that.
Yeah, I'm going to be doing some revisions to it.
Yeah.
Maybe by the first week of February, I'll have it done. And
Great.
by the way, while we're on the subject, I am going to be at a wedding next week in some city on Saturday in Mexico, but I'm taking my laptop with us, so it might not look as professional as it does now. I hope it looks professional, but I'm going to try and do it from the hotel room if I can get a decent internet connection.
Thank you so much.
So I am still planning on doing it from my hotel room. Maybe you'll see the background. Maybe I'll try to get in a picture of the ocean. Hopefully we have an ocean view. I don't even know what city we're going to. I think we're going to Puerto Vallarta and then having to drive 45 minutes. Probably most of you know where the hell that is. I don't, but we're going to be staying someplace. Anyway, what's your next question?
Yeah, it's not a question. If you like me to share with you or with the audience regarding that thing that I said last time about the fair housing and having to pick the first qualified one, because the attorney got back to me and he said that he goes to the meeting with those people. By the way, he's kind of the same like you. He's good. And he said he meet with those people in fair housing, and one lady, he mentioned her name, and he said she did also a webinar. He said this is a myth, and she told him this is not something that fair housing do, and people can always collect for some time the applications and then go through them and pick the what do you call it, the most qualified person. But then I'm gonna add from me also that I'm gonna pick the first and maybe the qualified, most qualified, and the first. That's what he told me.
And I'll tell you something, you might have
Yeah.
heard, Dina, of an organization called the Supreme Court of the United States. You ever heard of
Yes,
that one? Okay.
of course.
And there are 9 justices on that court. Okay.
Yes.
And every time there's a major decision, 5 go one way and 4 go the other. And this is probably like the most learned judges in the world. And how is it possible that 5 go one way and 4 go the other?
Right.
And thank God now it's 6 go one way and 3 go the other. Thank God.
Political.
But in any event, there's never in the law, there's always disagreements. There's always 2 attorneys in a lawsuit looking at the other and saying that you're wrong. I have specifically heard this from fair housing. I've seen lawsuits where people have sued. And as I said last week, if you choose to say, I'm going to take all the applications, I'm going to put them all in one pile, and the best one I'm going to take, I've seen lawsuits on that. And even if your friend, who I'm sure is not as good looking as me, even though he might have the same knowledge as me, even if you defend yourself in a lawsuit and you win, it's going to cost you $75,000, $100,000 to find out you're a big winner.
Right.
I do not recommend it. I always try to tell landlords, we have to be so careful because unfortunately, unlike the rest of the population, we have money. And when you have money, we're the target.
Right. Yeah.
Anyway, young lady, I'm going to say.
And you agreed also last time when you said that if through your firm you file lawsuit, and then as you're saying now that landlord pay money, but at the end turns to be their right. But you are right. We don't want to pay money. I agree 100% with you with that.
And no insurance will cover you for this. Anyway, Dina, thank you very much. I'm going to mute you, and we're going to move on to. We're going to do these in order so I know what I'm talking about. And let's move on to Rachel. Rachel, I'm going to ask you to unmute yourself.
Hi, good afternoon.
Hello, Rachel.
Hi, Dennis. I have a question. For East LA, unincorporated city of LA, I think we were allowed to raise the rents for up to 4% for January, but are we going to be allowed to raise the 8% in July?
Okay, well, I'm not, you're talking about unincorporated area of LA County. That's not
Correct.
the city of Los Angeles. And
Correct.
my thought was when they first allowed rent increases, it was 3%. The 8.8% is if your property is subject to statewide rent control, which it's not if it's located within the unincorporated area of LA County. So I think it's whatever it is. And I'm not sure what the county has approved. I know they came out 3%. I haven't heard that they've made a new decision.
Actually, they came out 4% starting January 1st, 2024. But I believe they were going to revisit a cost of living or an inflation, something or other, for July 1st of 8%. So I'm confused.
I have not heard that. You might want to call them or just, do a Google search on that. Okay.
All righty. Thank you.
Thank you, darling. Okay. Okay, let's move on to Gregory Poussin. I'm going to ask you to unmute yourself. Gregory, say hello. Last chance, young sir. Gregory Poussin. Okay, I'm going to mute you then. I'm going to move on to somebody who I think I know, who used to manage a very large property. And I'm going to ask Amarino to unmute herself.
Hello, Dennis. I think you're talking about someone else.
Okay.
I think you unmuted me. Yeah. My name is Douglas, actually, Douglas Moreno. So what I'm currently dealing with right now is a tenant that has had a 15-year-old lease. It's 2 pages. I'm taking over for my parents, and he's been just accumulating stuff around his shed, and I want to get him out. So I've been able to have him sign a month-to-month agreement. And I'm wondering if that's allowed or if there's any issues with me having him sign a new month-to-month agreement. And I use the AOA agreement, which has all these excuse me, all these addendums and all that, which looks like I can get rid of him if he does not move all the stuff that he's accumulating around the shed, and is also going to get in the way of me setting up a new parking lot or parking space area. So that's what I'm dealing with. Is it okay for me? Is that, I wasn't sure if I was allowed to. I just did it. I had him sign a new agreement.
Okay,
So
the first of all, what city are we talking about?
Pasadena.
Okay, so you can certainly have him sign a new rental agreement. That's true in any jurisdiction at any time.
Okay.
Also, if he has personal property stored in the common areas, then under that AOA rental agreement, which I helped author, that one would allow you to serve him with, I believe in Pasadena, it's a 3-day notice to get rid of the additional stuff. I'd have to check that. Let me see if I can check that real quick. Bear with me for Pasadena. Yes, that's a 3-day notice. And demanding that he remove the personal property from his common areas. And at the end of the 3rd day, if it's there, then you have the right to evict, young sir.
Okay, great. And this, I mean, I had him sign the new agreement this month, right? Do I have to wait a certain period of time before all those addendums actually take effect?
No, once you sign, it's part of the law. I might wait till next month, so it doesn't look like you're just seizing on him, but I think you're okay with that. By the way, your name is listed as A. Marino.
Yeah, it's, I guess my it takes in my middle name, Aaron. I don't know why it does that. Yeah, Aaron,
so,
Douglas Aaron Moreno.
And I
Yeah.
represented a woman by the name of Marino who had 5,000.
Oh, I see.
I thought it was her.
Well, I guess it kind of worked in my favor, but yeah, thank you for that.
Just to let you know,
okay,
you have to serve. Let me see if I can show this to you. Unless you're having our firm do it, let's share this screen again, just for the fun of it. And that would be this one. Share. Okay, so if you're seeing here the shared screen, let me make it even bigger. In Pasadena, right there, if you can see where it is, I don't know if it's showing where I'm pointing.
Yes, I can see it.
You've got to mail a copy within 3 days to the Pasadena Rent Control Board. That's their address there. And then, let's see, breach notice required 3 days. Yeah, so it's only a 3-day notice, like a standard 3-day notice to perform or quit. And then at the same time, you've got to mail it there. If you don't, then you're not in compliance with the law.
Got it. Oh, and real quick, so if he doesn't comply within 3 days, then what is it? I mean, he's been there for 15 years. Is it like a 6-day notice, or is it a 30-day notice? Okay.
No, then you hire the great Dennis Bloock, and we'll immediately start an eviction. I like when Janice is laughing. And we'll start an eviction for you. And what you're going to do is you take the before pictures, you take the after pictures, and it's proof. I mean, it makes the place look like a slum, right?
Right, exactly.
So anyway, that's where we stand. Nice talking to you, young sir. We're going to mute you, lower your hand, and we're going to move on to Eric S. Eric S., if you'd be unmuting yourself, please. There you go.
Hi, Dennis. How are you?
I am good, thank you.
Yes, Dennis, I wanted to know, I've been doing a lot of research on the lawsuit that was filed by I think it was the Apartments Association, when it comes to the 30-day notice that the county is requiring us to give to our tenants. But it appeared that that law was granted a few days ago, and the judge struck it down.
Yeah,
the 30-day requirement.
I haven't seen that. I'll take a look at that, and I'll keep you informed at the next show. I haven't seen that. I have myself been involved in a personal trial where I'm suing let's just call it an eviction firm. And I've been involved in a jury trial. This case has been going on for 7 years. So I'm going to be talking about it shortly. I don't want to give any names or what it's about at this point in time, but I think if it goes the way I'm trying to make it go, then I think there'll be incredibly happy landlords out there. So, but in any event, yeah, I don't know that it just passed. Been a little bit out of the loop this last week, spending all my time in court. But if that's good news if they're not requiring a 30-day notice.
But how does that affect the landlords that have given a 3-day notice for that period of time, which we should have given a 30, would that affect our cases? If this law indeed,
Well,
this
I
law
would
was struck
think the
down?
courts would say that since when you served it, a 30-day notice was in effect, then you should have served a 30-day notice. That would be my guess. But
Oh
again,
my
I'd like to
goodness.
review the law.
Okay. All right.
All
Thank you
right.
so much.
Take care. Well, now finally, we're going to get to somebody who has their video open so we can see what people look like. I'm going to ask Crystal to unmute yourself so we can see you, please.
Good afternoon, Dennis. Thank you for
Hello,
hosting
Crystal.
this. My question is, I have a single family residence. It's only one house on the lot. The tenant has been there more than 12 years. It's a Section 8 tenant. Given that, how much can I raise the rent by? It's
Okay,
in the
first,
city of Los Angeles.
okay, first of all, regardless of any rent control laws, you can only raise the rent to what Section 8 allows you. So you can make an application to Section 8 to raise the rent, but if they don't grant it, then there's nothing you can do. You'd have to figure out a way to evict that tenant and get somebody else in there. Then you could set the rent to whatever you want. If you weren't under Section 8, you could raise the rent to whatever you like. But Section 8 and the contract that you signed. Now, the only thing I would suggest in that situation is if you wanted to renovate the house, because we're still under what they call the just cause ordinance for the city of Los Angeles, even though you're not under the rent stabilization ordinance. So if you were planning on, let's say, redoing the kitchen or the bathroom, remodeling, we could ask that tenant to leave. We'd serve a 90-day notice on the tenant. We'd comply with what the city wants us to do. And then you'd be able to evict that tenant. You would have to pay relocation to the tenant, but the relocation is only 1 month's rent.
Okay, my follow-up question is, I was unaware about that, the AB 1482, where you have to put a notice on their door or whatnot, saying that since it's RSO, it's exempt. Does that notice need to be signed? And if not, how many days after, is there like a waiting period? Like, can I post that notice on Monday and then on Tuesday, request a raise in rent?
Okay, the raise in rent has nothing to do with the posting of that notice. So that's number
Okay.
one. So you just need to post that notice. It's a single family home, so you're only going to do the one that says Tenant Protection Act. That just has to be posted. Go over there, post it someplace on the property. For everybody out there, if you have residential property in the city of Los Angeles that you lease, you have to have this renter's protection notice posted somewhere. I don't care if it's a $85,000 a month Brentwood house. This has got to be posted in a conspicuous spot on the property. So says the city of Los Angeles. If your property is under RSO, the rent stabilization, in addition to the eviction protection, the tenant protection notice, you also got to post the other one. Both of those notices, I am happy to tell you, are on my website posted, but it has nothing to do with asking Section 8, hey, I want more money for this. Now, in order to justify it to Section 8, I'll give everybody a little hint out there. There's a beautiful website, which I've talked about before, and that is called Rent-O-Meter. That's R-E-N-T, the letter O, meter.com, all one word. And in that, you can put in your property address, you put in how many bedrooms and whether it's a single family home or not, click the button, it's free for the first 5 times, and you're going to be able to see an analysis of what that's worth. I would print that out, I would send it to your wonderful Section 8 advisor and say, look, this is what the rents are in this neighborhood. If you want me to continue on, I want to get more money, and see if she'll bite on that. And thank you very much for your question. I'm going to move along because we do have a lot of callers in here, and I'm very happy that we do, by the way. And let's move on to Leonard. Mr. Leonard, I'm going to ask you to unmute yourself. Thank you.
Yes, hi, Dennis. Quick question for you. When you're actually on the case I'm working on now, that where a tenant that I'm having hopefully be evicted. The 3-day notice is passed. You're now going through with the courts.
Well, now my good friend, ask general questions. I don't talk about specific lawsuits unless we're at the office.
No. The only question I have is, once you give them the 3-day notice with the specific amount, that's the amount that was due at that time. But when it does happen to be stretched out another 2 more months, or as the tenant's there not paying, how do you get that extra rent once you do win? And I mean, does it automatically apply, or do you have to resue her again for that extra amount? Or how does that work for if she's there for an extra 2 months by the time she actually leaves?
Very simple. When we sue, we're suing for the amount that we're asking in the 3-day notice, but we're also asking for the daily rental amount for every day past the notice. So let's pretend you served a notice in December for 1 month's rent, and let's pretend the rent's $1,000 per month. In addition to seeking $1,000 per month, we'd also be seeking $33.33 per day. That's 30 divided by 1,000 for every extra day. So it's automatically computed and put into the judgment for money until the end of till the tenant is actually evicted.
Perfect. Okay. Thank you very much.
My pleasure, Leonard, and thank you for calling. Let's see. Let's move on to Karen Kahurara. I just butchered your name, but I'm going to ask you to unmute yourself. There you go.
Hi, Dennis. Thank you. Thank you, Leonard, for that question. That I was wondering the same. But my question is in regards to security deposit itemization form. I have yours in front of me. Now, if the keys were not returned and if there was abandoned property and there's storage involved for the 18 days, does that go on a separate invoice, or
from a security deposit, you're allowed to deduct for unusual wear and tear, like the guys punched holes in the wall, or the kids, did crayons on the wall. You're allowed to deduct for reasonable cleaning, and you're also liable for any rent owed up until the day they vacated, or actually for the remaining portion of the lease if they left their lease early. Now, for the changing of the keys, that they didn't leave the keys, quite frankly, young lady, you need to change the keys anyway. You're not going to have a tenant with an extra key be able to break into the house of the new tenant who you just rented to. So I don't see that as in any way that those keys have any value. You need to change the locks anyway.
Right. It's kind of symbolic, really. I mean, even if
it's symbolic that he's giving you possession of the premise, but it's not something that you can deduct from a security deposit.
Okay. And what about abandoned property storage?
Well, abandoned property, they have 15 days. There's a form that's on my website. It's actually 18 days. And you mail it to the last known address, which is your property. And you don't have to keep it there. You can put it into any locked storage area. And he's got 18 days to retrieve his belongings. If he wants it, then you can technically charge for the storage charges, not like, in your $20,000 a month house. You just put it in the garage and whatever a storage company would normally charge you, which is not that much. And after the end of the 18-day period, if he hasn't retrieved his belongings, they're deemed abandoned. And you can toss them if they're worth less than $700. If they're worth more than $700, then you're going to have to hold a public auction. And hopefully that answered your question. I am going to move on to, I think this is a client of mine, Richard Klug. I'm going to ask you to unmute yourself. Richard.
Good afternoon.
Hello.
Yes, we met before. Anyway, we're coming upon this February 1st date. I have one person who has moved, one person who's still in the building, and I wouldn't mind them staying in the building. So the one that's moved, how do I proceed to collect the funds? And then the one who I want to stay in the building, same thing, I guess.
Okay, let me get this straight. We're talking about one unit with 2 tenants in that unit?
No, we're talking about 2 separate units.
Okay, in what city?
City of Los Angeles, in a non-RSO building.
Okay, and did the tenant not give you notice?
The one who left, we filed with a certain attorney for detainer, and that scared her out.
Okay, so then that, assuming she was served with the lawsuit, then that attorney could then proceed forward with the case and obtain a monetary judgment, even though the tenant's out. If you didn't get the tenant served, then you're going to have to sue her in small claims court. So that's with regard to tenant number one. The other tenant, I'm guessing you are also suing, but that tenant is still in possession, correct?
No, I'm not suing that tenant.
Okay, then what's the story with that tenant?
That tenant has been paying ever since the whole moratorium is over, and he's paid on time.
Okay, so then we only have a problem with the one where you had to file an eviction lawsuit, and in the middle of the eviction lawsuit, that tenant left, and now you're saying how to get the money. Again, if your landlord, if your attorney has had him served, the attorney can then proceed forward with obtaining a monetary judgment. If he wasn't served, you're going to have to serve in small claims court.
Yeah, actually, the attorney was your office, and we settled that she would leave. So we settled the case. So I have to do the small claims, right?
Well, it all depends. If during the course, and again, generally speaking, my good friend, if during the course of the case that you settled where you waived your rent, if that's what you did, then you can't go for small claims court. However, if she owed you rent, for example, during the COVID period, like I was talking about at the beginning of the show, then you could go to small claims court for that. But if you waived the rent in the lawsuit in question, then that rent's exempt. Okay?
Got it. All right.
Okay, my friend. Thank you very much.
Thank you.
Let's take a look here. If you would mute yourself, I would appreciate that, sir. And let's move on to Greg. Greg, I'm going to ask you to unmute yourself and say hello.
Hello. Can you hear me?
I hear you.
Hey, so I'm kind of spinning around with the Section 8 law where we can't use the credit score. And I need a little bit of help because we've had a lot of Section 8 people applying to our properties, which they used to not. One of the first questions I have is, and I think you kind of touched on it before, but if we have other applicants in the pool, we can address those applicants as far as qualifying first before we go to the Section 8. Is that correct?
Oh, absolutely. It's the first qualified applicant. But what you're talking about, Greg, for the audience, is that while you can't discriminate against Section 8, I've always advised my clients, sure, don't just say, I'm not taking a Section 8. Take their application, check their credit, and if their credit is bad, then of course, in the past, you were able to reject the applicant. But come January 1st, they go under a theory of the ability to pay. So their credit score is irrelevant based on this new law. And if the tenant can prove that he has the ability to pay, even though he probably doesn't pay any one of his other creditors, which is why he has a low credit score. But if he can prove to you that he has the ability to pay, that would be a substitute for his credit score.
Okay, so like this guy first, I called the Section 8 people at the city that we're involved with, and they told me the maximum that they would pay is $2,100, which the rent was $2,400, and he only made $400 from Social Security, and that's all he provided me. He didn't provide me the voucher.
That's a good thing. If you're leasing the premises for $2,400, I'm not going to take a Section 8 if they're only going to give me $2,100. So that's a legitimate reason to say this has nothing to do with your credit, your ability to pay, or Section 8. This has the ability, I'm renting this place for $2,400. If you don't want to pay me, bye-bye.
But the thing is, it's kind of strange. Immediately he came back and says now that he's got a qualification with his girlfriend, and now they're up to $2,400. So now that covers the rent. And so
okay, then that's fine then. I mean, that now what you need to do is see if they have the ability to come up with whatever their share is, which is probably around $400.
Okay.
But as long as Section 8 is going to give you that. Now, remember what I was telling in previous shows. If you consistently, as your policy, only rent the premises for everybody only on month-to-month tenancies, and that's what you do, that's your procedures, see if Section 8 will accept a month-to-month tenancy for $2,400. And I've been told, though I don't know personally because I don't take Section 8, I've been told that Section 8 will not lease the premises to you unless you're offering a 1-year lease, which you're not.
We don't, that's policy, thanks to you. We don't do that because of the state rent control and all the things that come with it. But
Perfect.
now, do I tell him that? Can I tell him, like,
No, say I'm happy to rent. I'm happy to rent to you. Please demonstrate your ability to pay the amount that Section 8 is going to ask you to pay out of the 2,400. Oh, and by the way, this is going to be a month-to-month tenancy. I will not sign a 1 year's lease, but I'm happy to sign that. Please
And that's
come on down.
Okay, and that's on our website, so they can see that. That's for everybody. Okay.
I love it. Good
all
thinking,
right.
Greg.
All right. Thank you.
Thank you, sir. Okay, so we're going to move on to Keith Palafox. Keith Palafox, come on down by unmuting yourself. I gave you such a good lead in, Keith. Come on, don't disappoint me. Okay, Keith, we're going to move on. Let's move over to Harold. Harold, I'm going to ask you to unmute yourself.
Hello, can you hear me?
I hear you. I see you.
Hi, Dennis. I've done some transactions with you in the past and was very thankful for what you did to help me and some of my clients.
Now, how often do you go into that pool behind you?
When it's basically 90 degrees, I'll jump in. Like when it's 80 degrees out, it's borderline.
Now, I have to tell you a story. I have lived in my house now since 1999. I guess that's 25 years. And I've never been in the pool. I'm not a pool guy, so that's why I asked you. But it looks like it's very open in there. Is it closed behind you? Are those windows behind you?
No, they open up. They open up.
It's very nice. This kind of open flow.
Yes,
I love that.
I'm kind of nearby you. I'm in Woodland Hills, so
very nice.
Fastest though.
Okay, Harold.
Anyways,
what's your question, sir?
Okay. I have a house that I rent out one room because I've been so paranoid. I used to rent out all of them, but when all the stuff went down with the city, everyone left, but I had one person left. He's been there for 3 years. I was curious, since they have that thing coming up in November where they're going to vote on getting rid of the Ellis Act or whatever that name of that is. You said, try to raise the rent as high as you can, that, market rate. So what I was thinking of, you also, I think, said you can do it more than one time a year if you're owner occupied, City of LA, single family residence. Is that true?
Okay, so you have one border, correct?
Yeah. Yes.
Okay, so you can raise the rent as much as you like, whenever you like.
So what I was thinking of is raise it $200, like for the 3 months from now, and then near when that November, depending on what happens in November, if it looks like we're screwed, then raises rent again to market rate. And if you want,
right, but you have another option, and your other option, since you're in the city of LA, it's a single family home, only one house on the lot, and you rent that one room. Is that the facts?
Yes.
Okay, so you can just say, I want you to move because I want to occupy the whole house.
I was talking to another attorney and they told me it doesn't apply to me because I live in the house, so I'm not an owner move-in, and I didn't believe him.
And you shouldn't have believed them, because we can easily do that case. You're going to have to pay them relocation, which is a whopping 1 month's rent.
Now, by the way, if that thing kicks in where they get rid of the Ellis Act, it's extremely possible the city council come in and destroy everything we've had leverage on. Like even this situation.
Well, I don't think they're getting rid of the Ellis Act. They might be clamping it down a little bit, but they're not getting rid of it. A landlord always has the right to go out of business.
Yeah.
So unless you're thinking of another term, but the Ellis Act deals with the right of an owner of property to permanently take that unit off of rental housing use. That's when you want to evict two tenants from, let's say, like a duplex, because you want to tear it down and build another big unit, as I had a call today on that.
Right. And just a quick caveat, if I get him out as an owner move-in, am I off the rental market for the next year or two, or is there a penalty for that?
Well, yeah, you wouldn't be able to re-rent it for at least 2 years.
Oh, 2. He told me 1. Okay. All right.
2 years.
Thank God I talked to you.
All right. Thank you, sir. I think I cut you off a little bit. I'm going to try one more time to Keith. Let's see if I can get you to unmute yourself. I'll give you one more chance, young sir. Keith, are you there? Okay, we're having technical difficulties with Keith. Let's move on to Van Johnson. Van Johnson, come on down.
Hi, Dennis.
Hello.
I am asking a question kind of along the side of the last question. I have two single family houses and I want to know about renting out a room. So I started looking up the law in Los Angeles. Do they treat you like an RSO if you rent out more than one room to two different roommates? And how does that compare with unincorporated Los Angeles?
They're both really the same. They're considered, if you're renting out more than one, the city's trying to say you're running a boarding house and you don't have a license, so therefore this is an illegal tenancy. So I would not rent out more than one room in your house. I know many clients do it, or sometimes they'll have a house, they don't even live there, they rent out 5 rooms, and they make so much more money than if they rented it to one family. But it's just not worth it in the city of Los Angeles.
And the unincorporated is the same.
It's the same. So
thank you.
All right, you take care. All right, let's do Anna. Hello, Anna. How are you? Unmute yourself, young lady.
Hi, Dennis. How are you?
I am fine, thank you.
Dennis, a couple weeks before, I asked you a question related tenant lawsuit to the landlord. And you told me that if we got lawsuit, you can help us to work with our insurance company. I like to know if we got lawsuit, we should have to contact with you at first, or we have to call insurance company, open claim, then contact with you.
I would call us first because we'll lead you through how to deal with the insurance company. Many times we can get the insurance company to pay our fees. So definitely contact us if you have it and we can get you to where you need to be.
So you guys open claim behalf of us?
Yes, I would call us first, young lady.
Okay, and my next question related same topic, like insurance company, it's I know they pay for my defense attorney, but they normally approve the claim. They took all the claims, like any type of claim. It's a lawsuit come from the tenant, or depends what's the wording of lawsuit, depends what's the title of lawsuit.
Whether you have insurance that will cover this problem depends on, number one, what type of insurance you have, and number two, what the tenant is suing you for. For example, if the tenant is suing you for intentional conduct, no insurance company is going to pick it up. Sometimes, for example, the tenant could be suing you for mold, but your insurance company doesn't cover mold.
But for breaking contract, keeping full, keeping wrongfully keep the deposit, or wrongful eviction.
Yeah, I mean, there's all sorts of things that you can get sued on. But anyway, if you do get it, hopefully you don't, but if you do, then give me a call. Thank you for calling in. I am going to now move to somebody with a video, and that is Cheryl G. Tell. And if you can unmute yourself, I'd appreciate that. Cheryl.
Yes, sir. Okay, I'm here.
Hi.
Okay, hi. I have 3 succinct questions. The first has to do with the residential rental agreement that I have in place. I have a tenant. She's been there over a year. So my understanding that is based on what I have in this term is that it converted to a month to month, but I just want to read you this one line.
Can you tell me what city first?
Oh, I'm sorry. The property is in Downey.
Okay, go ahead with your line.
Okay, so it says owner and agent accepts rent from tenants other than pass-through rent, in which case a month-to-month tenancy shall be created. Now, my understanding is that means that this one-year lease automatically converted to a month-to-month. However, my husband thinks I actually need to create a month-to-month, a brand new month-to-month lease.
Your husband is a very smart person, and I'm sure you have a great marriage, but your husband's wrong.
That's what I said, but okay.
Don't tell him. Don't tell him that I said that, okay?
Right, I won't tell him. All right, so yes, that was my understanding as well.
Now, is this, as an aside, is this a house or an apartment?
It is a little house. There's 2 little houses.
Okay, so 2 houses on the lot, then you're under statewide rent control. By the way, you can raise the rent 8.8% by just merely serving a 30-day notice.
Okay,
8.8%.
all
And-
right. Well, I think we're in a pretty good spot on the rent there. So, and she's a good tenant, but I will keep that in mind. I do have another person, the other property, the person just moved out, which is my second question. So the person gave me a 30-day notice, but they actually were able to move in 25 days. In addition to giving them their security deposit, do I pro-rent that 25 days? They gave a
tenant has
30-day
to give-
notice.
Yeah, a tenant has to give you 30 days notice. If they move out and they don't pay for that 30 days from when they gave it, they owe it to you. If in fact they paid you 30 days, but they moved out in 25 days, you don't have to give them any credit back.
I do not. Okay, because she
No.
did pay for the month of January, but they moved.
They moved 5 days early. Well, guess what? Too bad. You know?
Okay, all right. And my last question is, I would really
Last
like.
one, darling, because I got a lot of calls.
It's short. I've been calling your office. I'm trying to get an appointment. I want to pay you guys to review my existing lease before I get a new tenant, to just make sure everything is the way it's supposed
Why don't
to
you
be.
use our online form and upload the lease and state what you want? It's on our website, evict123.com. Say you want
Okay.
to, there's a button that says start a new case, upload the lease, give me your questions, and then we'll call you back. Okay, darling?
Okay, perfect. Thank you, sir.
Bye-bye. Okay, let's move on to the number 8, or Octavio. Please unmute yourself, sir. Octavio. Hello.
Dennis, thanks for doing this. Appreciate it.
Hi.
So I wanted to know if I have a friend who was given a 60-day termination notice, and also that it was exempt from, or that it is exempt from AB 1482. However, it's a single family home, and the landlord is it says partnership, qualified.
A limited liability? Or
Qualified
limited
opportunity fund.
partnership?
Qualified Opportunity Fund Partnership. Are they still exempt from 1482?
The only one that's exempt from 14, which makes 1482 applicable to tenants, would be if they, if it's in a real estate investment trust or a corporation. Anything else would still be exempt. However, when did your friend move in?
Moved in, let's see, 2 years ago.
Okay, so he is subject, or the landlord is, and the tenant is subject to AB 1482 unless there was a phrase written in the contract that says this property is a single family home and it's exempt from statewide rent control. If it isn't in the contract, that phrase, then your friend then your friend's under statewide rent control, even though it's a single family home, and he has, they can't just serve him a notice, to 60-day notice to get out. So
Got it.
hate
It has
hate
to
to
be
give
in the
tenant
contract.
advice, but I'm doing it.
No, I got you. Okay, and then one more. Can a landlord evict? This is for a condo or townhome. Is that considered single family home, like same exemption?
First of all, what city, young sir?
Oh, it's Inglewood.
Okay, so it is not considered well, Inglewood, it has its own rent control, and that, trying to think whether they accept condos or not. I'm actually not sure. Inglewood generally follows 1482, the statewide rent control, and statewide rent control does exempt condos. However, with regard to the condo, nothing prevents the landlord from raising the rent to market value, regardless of what's in that lease or not.
Got it.
So if you want to
Okay.
raise the rent, go raise the rent.
Got it.
Okay, we are going to move on to, did we talk to Anna yet? I don't know. Anybody know? Shake your head. Nope, I don't think so. I'm going to ask Anna to unmute herself. Hello, Anna.
Yes, David, it's me again. My question, I have a tenant, they trying to break the lease. And we come in agreement that they paying me 1 month worth of lease, and I release them. There is any type of release or early termination lease agreement on your website?
We have a standard lease that's either can be month to month or a fixed term lease.
Okay.
If you want to, and I do got to move on, if you want to do an early termination, you just have to do an amendment to the lease, Anna. Okay.
David,
I got to move on, sweetheart. I love you, but I got to move on. Sorry, darling. You got two questions out of me. I'm going to move over to Lisa D. I'm going to ask you, Lisa D, to unmute yourself.
Hi, can you hear me okay?
I hear you. I see you. Thank you.
Great, thank you. And I'm also a client of yours. I have a question on notice to vacate for Section 8 tenant. It's a single family house in Santa Clarita. She's been there for a very long time, over 10 years. She signed a new lease in January of 2020. She's now month to month. I did give her proper just cause notice in June of 2020. I used your form for 1946 and 1947. I want to sell the house. I know I need to give her 90 days, which is fine. I know I need to provide that 90-day notice to the county. I've already spoken with them. I'm wondering if there's anything else I need to do, and if I give her any rent.
Number one, you need to put the reason in the notice. The reason in the notice is that I am terminating this tenancy for economic reasons because I'm intending to sell the property. I am terminating this tenant for economic reasons because I'm intending to sell the property. That's number one. Number two, you have to serve that 90-day notice. You do have to send a copy. This is unincorporated area?
Santa Clarita.
Okay, so it's a city.
Yes.
So if it's a city of Santa Clarita, there's nothing to be sent to the county, but you do have to send a copy of the notice to your Section 8 advisor.
Yeah, that's what I mean. The Section 8 county folks.
Yes.
Okay, economic reasons because I'm intending to sell the house.
You got it.
That's included in the 90-day. Anything else?
That's about it, young lady.
Okay, right on. Thanks a lot. Appreciate it.
All right. Thanks for the patronage. Okay, let's move on. I am going to move on to let's move on to a color. I'm going to pick the color orange. Orange, I'm going to ask you to unmute yourself. Little orange, are you there? Last chance. Okay, we are going to move on to iPhone. iPhone, I'm going to ask you to unmute yourself by hitting *6 if you're on a phone. *6. There you go.
Hello?
Hi there.
Hi, thank you for holding this event.
Every Saturday at 3 p.m. Even if I'm in Mexico, I think I'm doing it.
That's great. Thank you so much. Thank you. The original tenant that was on the lease, she passed away, and the tenant who wasn't on the lease started paying for the rent.
Okay, so am I to understand that there were two tenants on the lease and
No.
one tenant passed?
No, only one tenant was on the lease, and
Yeah.
then the other, I guess she had her husband living with her. He wasn't on the lease. And
Okay, but while she was alive, first of all, what city?
Chatsworth.
And this is a single family home?
Yeah, it's a townhouse.
Okay. And with regard to, did the husband ever pay rent while the wife was alive?
Yes.
Okay, so he's your tenant, like
Okay.
it or not.
Okay.
And even though she passed, you now have, and you've been taking his rent, so you've established an oral month-to-month tenancy. But the good news is, if you want to get more rent, just serve a notice. If you're going to serve a rent increase that's in excess of 10%, then you'll have to serve a 90-day notice. If it's
Right.
10% or less, it's a 30-day notice.
Okay. The problem is I don't know if he's going to pay rent next month because he's in the hospital. He might be passing away himself. And
I guess death runs in the family.
yeah, they're very old people. But so yeah, according to I don't know what to do. Am I supposed to
Well, it's not a matter of knowing what to do. You have to see what's in front of you. So
Right.
rent's paid or it's not paid. If you get your rent, you're happy. If you don't get your rent, then we're going to serve a 3-day notice and we're going to proceed forward with an eviction. Simple as that.
Even though he's in the hospital. Okay.
Hospital, no hospital. I mean, you can be gracious if you want, but it is what it is.
I can't afford it. Okay, thank you so much, Dennis. I really
All right,
appreciate it.
bye-bye. And I wonder why she gets the name Orange. Anybody can figure that one out, let me know. Let's move on to Sen Chu. I'm going to ask you to unmute yourself, Sen Chu.
Yes, I did.
Hi, how are you, sir?
Hi, Dennis. I'm doing great. Appreciate first time I talked to you, but I listened to your show for quite some time. I have two questions. The first one is basically I will certainly need your service for a eviction notice, because I think the tenant have violate my lease. The other one is just minor. Basically, I had a fixed lease with him and his girlfriend in 2020. And his girlfriend 2 years ago have written a request to remove her name from the lease. And so I've been talking with him to basically renew the lease. So the lease now turned from 1 year lease to basically a month to month. And then during that time, this happened, right? The woman want to remove her name.
Okay, let me get this straight. You had a man and a woman who rented your property, correct?
Yeah, it is a duplex in Los Angeles.
Okay, but they're renting one unit, correct? One side of the unit, and they both signed. Did the man move out?
No, the woman had moved out, and
okay, so she's asking to be removed from the lease.
Right.
It was the lease a 1 year lease?
It was a 1 year lease in 2000.
And now the year is gone.
Right, it's gone.
And
yeah.
so it's month to month. She wants to be removed from the lease, and the man continues to pay the rent.
The man continued to pay, but he refused to amend the lease to remove her name. The reason is I asked him to. That would lead to the second question.
Okay, well, whether she's on the lease or not, you basically control the show. So he's saying, I don't want her to be removed from the lease. Well, that's nice. But if you were going to, let's say, sue him for non-payment of rent, you don't have to sue her. I guess you could sue her because technically a partnership rented the premises. And when the partnership vacates, then each individual member of the partnership is not responsible. But in this case, if you don't want to sue her, that's fine. So I don't know what his motivation is. She's obviously not coming back. But he said he's trying to keep her hostage on the lease. Say, okay, her name's on the lease, but I'm never going to go after her. So
right. So that the woman is not the issue. The issue is like this. Since that woman moved out, he harboring 2 other women as an unauthorized guest since some years ago. Yeah. So and on top of that, about 6 months ago, he relocated out of state to New Mexico and work there. But he want to continue keep the 2 unauthorized guests on the premise. Do I have ground to evict him? Can you
absolutely, because pursuant to the terms of the lease, you have unauthorized persons occupying the premises.
Right.
So we would serve it's a 30-day notice to perform or quit, since the city just continued on with that crazy law. It used to be a 3-day notice. Right. But we'd serve a 30-day notice, and if those women are still there at the end of the 30 days, we have the right to evict everyone from the unit, and we don't have to include one of the signatories, which is the girl who vacated.
Right, wonderful. So it's not true that I listened to your show about a week or 2 weeks ago. I remember you mentioned that in LA, the tenant is allowed to bring in 1 guest.
The tenant is allowed to bring in 1 guest if the tenant asks you first, allows you to screen. If they just bring in 2 extra people, that's grounds for eviction.
Got it. So then that's great. Now get my second question. So when I 1 year into the lease, I give them a verbal permission to use my backyard as a portable garden. And there are 4 terms to it. One of the bigger terms is that it's a portable garden. You're not supposed to have any tree, no vine on the metal fence on the neighboring border. And so they violate that
but this is the same people we're talking about, correct?
Correct.
Forget the grass growing and the vine and this and that. They got 2 extra people there. You got a great case for eviction, and your tenant's not even there. So this is, if you want to get rid of them, this is a perfect opportunity. And I happen to know a firm that could do that for you. Okay.
Wonderful. Yeah. So what can I contact you with your 101
just
number?
Call me. You can call me on Monday if I give this out during these meetings, that if you want to just talk to me only, when you call in, hit my extension 1001, you'll get connected to me only. I do have 25 attorneys. They're wonderful, But if you
Right.
just want to talk to me, but that extension, ladies and gentlemen, is only between the hours of 7 to 8 a.m. If you
Right.
use that extension any other time, I will slam the phone down. But otherwise, for that 1 hour, Monday through Friday, I will talk to you. I'm going to say goodbye to you,
Brilliant.
Sen. Appreciate
Well,
it. Sorry, young sir. Doesn't. Sorry. I got to move on. I'm going to take one last caller. Let's move on to David. I'm going to ask David to unmute himself. That'll be our last caller. Say hello, David.
Thank you very much for everything you're doing. 2 quick questions, very brief. If a duplex has one unit in the front that is built by permit and the other one in the back has been built for a long time without a permit, and a tenant lives there for many years, does he have the right after many years to come back to you and say, you know what, I need all the money I paid you for the rent back to me because this was not an allowed unit that I lived in?
And the answer to your question is a tenant can say anything he wants because this is America and there's something called free speech. But if you're asking me whether he would be legally able to get all of his rent back, there have been many cases filed. Very few have been granted in favor of the tenant. The tenant was given the use of the premises, and it's a theory called quantum merit, which I learned in law school, unfortunately, 50 years ago, believe it or not. I know I look really young, but really it was 50 years ago. And the fact that they got value for their money doesn't allow them. Now, if your property is located in the city of Los Angeles, you'd have to pay relocation if they stop paying rent. Where is that property located?
This is in another state, but I'm just asking you.
Oh, in another state, I have no response. I'm not giving any advice for another state. I was thought you were talking about this one. Anyway, ladies and gentlemen.
No, my last question, quick. The renter's insurance, how do you handle that with a unit that is manager occupied? That's a very quick question I have for you.
Well, I mean, you could make it a term of your managerial agreement that the tenant has to pay for it, or you could pay for it for them. I mean, it's whatever you guys decide, okay?
With the manager, right? Okay.
You got it. I'm going to say goodbye to, let me finish up, kids. I'm going to say goodbye to everybody. We had a big turnout today. I'm very happy about that. And tune in next week, and maybe you'll get to see the ocean in some city I am in Mexico. God only knows where I'm going. But I'll try to do it from them, and check the website. If I can't get a connection, then I might not do it, but trust me, I want to do it. So I'm signing off. This is Dennis Bloock from Zoom Landlord-Tenant Radio, and a good afternoon and have a great weekend, everybody.